It is March 8th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today we have an incredible compilation of court moments spanning 3 distinct dockets. We start with Judge Middleton dealing with a defendant he calls the Tasmanian Devil of Chaos. Then we move on to Judge Johnson hearing a wild excuse about spiked hotty-toddy tea. And then we finish with Judge DiSanto handling a 90-mile-per-hour high-speed chase that ends in a dramatic foot pursuit. You definitely don't want to miss any of these hearings, ladies and gentlemen. It's a night full of lies, consequences, and last chances. Grab a snack, get a drink, and buckle up. It all starts right now.
Good morning. It's early. I'm starting a little early this morning. It's 8:03. Raymond started at 8:15. This is our next to last day here in this courtroom forever. Jeanette Jackson is here with me. One of our customers is here already. Good morning, Australia. Jeanette started in February of 1980. I started in May of 1980, and we practiced our entire career in this courtroom in front of Judge McManus for a long time. And then here, I've been here for 24 years. So we're about 90% moved out. It's still messy and chaotic around here, but we're going to be fine. They've moved Judge Pattison almost completely, and they're setting up his new hearing room in the other building. And while I'm gone next week, hopefully they will be setting my stuff up both on the bench and in my office. And I did get a new chair, well, a used chair. I don't know where it came from. There's so much moving around. There's spare furniture all over the place, file cabinets, drawers, shelving. Anyway, today's first line, I think we need it. It came to me as I woke up at 5:12. It just popped into my head. And usually I don't think of the song till the day before, or sometimes I have a couple banked. This one just came to me. And if you don't know it, you should. If you do know it, sing along with it. It's another 60-year-old song from a 70-year-old man. Anyway, it's the kind of song that makes you smile. So listen to this later and smile. Before I start with the first line, I have to say, I Dig a Pygmy by Charles Hawtrey and the Deaf Aids. Phase 1, in which Doris gets her oats. Many of you already know what it is. 2 of us riding nowhere, spending someone's hard-earned pay. You and me Sunday driving, not arriving, on our way back home. We're on our way home. So listen to that today. It'll make you smile. Sing with it in your car. And hope it is a little shared moment of humanity. I will presumably, at least the plan is, to be online once again on Tuesday, April 21st. I may bring an assistant in with me when I come into the new courtroom. As you know, generally we're in here by ourselves. There's no clerk, there's no recorder, there's nobody. But the next judge who's going to succeed me it's gonna come in cold, so I think we may start to train somebody to help him. I've never been in another Michigan courtroom that didn't have a clerk in the courtroom. They do in probate court, they do in circuit court. They could make things go faster by providing notices, printing notices, giving stuff, getting things. So we may bring somebody in the courtroom when we get to the other side. So we have one customer. He lives here in town. He's early. We have another customer.
That's right.
Good morning.
Morning.
You wanted to come over for our next to last day here?
That's right. Was today the next to last day?
Oh,
Yes,
yeah.
it is.
There you
It's
go.
history, the end of an era.
The end of, well, I think that era can end and we can go and update this place.
Yes.
Judge Weigel sends his best and he said, well, tell him that the renovation is worth it. And I said, well, he won't be there for the end of it. So
Yeah, I won't be there. I'll come back and visit, but I won't be here
that's
to,
what I said, he'll just get to go through the rough patches and not to experience or enjoy the end result.
the last day streaming will be tomorrow until April 21st. Good morning, sir. Are you Stephen Anthony Bird Jr.?
Yeah.
You got a ticket on March 18th at about 9:30 at night, Chicago Road and Prospect Street in the city of Sturgis. They also charge you with speeding. And Officer Nathan Johnson of the Sturgis Police Department elected to charge this under state statute
I don't know.
instead of city ordinance. Boy. Anyway, let's talk about this. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail, and fine of up to $500. Impeding traffic is a civil infraction. It carries a $100 fine. This was written in Sturgis, and it would have been a lot easier if they wrote it under Sturgis ordinance, but they wrote it under state statute. Let's take a look at your driving record. You got Indiana issues, is that correct?
Yeah.
Have you done anything to get your license back in Indiana?
Yeah, they told me to watch driver safety program and I have to also get like an SR22 for 6 months of it.
It takes 6 months to do that?
Yeah, I have to hold the insurance for 6 months, yeah.
Oh, but when would you be eligible to get your license back?
Once I finish my insurance and the videos,
So that takes at least 6 months?
yeah, 6 months, yeah.
Well, they aren't gonna wanna delay this 6 months. Well, if it was a city case, I could take care of it right now. Why don't you have a seat? We'll see if we can get, do you have any paperwork with you for Indiana?
Oh, no.
Well, I would adjourn it. And have you come back in a month or so. And not eligible for license, traffic safety or federal rule expires 11/14/20 something. You weren't really doing much of anything. Driving record is cut off. I can't, your suspension expires 11/14/20 something. And I can't read the rest of it. Are you working? Do you live in Sturgis now?
Yeah, I do live in Sturgis, yeah.
Where do you work?
I work like 2 fast food places, KFC, and I work Wendy's in Sturgis.
For you. You're restricted from Indiana, but you live in Michigan.
Yeah.
So you can't get a Michigan license because of the Indiana issues. And I can't read this darn driving record. So I'm debating whether to have you just try to talk with the prosecutor this morning or have you come back in about a month. Can you make any progress on this in a month?
Yeah, I could, I can get my insurance and, watch the videos next month or just later on this month.
All right. There's a charge called allowing another to violate the motor vehicle code, which would not affect your ability to get your license. So I'm gonna adjourn this for pretrial with county prosecutor. About a month. So I'm gonna adjourn it to May 21, May 13th at 8:30. I don't know if the officers charge it under state law just out of benign laziness and they check the wrong box.
I think a lot of times it's the wrong box getting checked as they're going through.
I talked to the chief in Three Rivers and he did, I mean, they can charge it any way they want, but then you don't have the authority and the city doesn't get the fine money.
Generally on something like this, our intention is to charge it under local ordinance. It's been practice, but as you notice, time to time they box not checked.
This will be in the building across the street by the time, or across the way, not across the street, the historic building. So bring your license in full.
Okay.
And we'll see what you got, and if the prosecutor will give you some consideration. In the meantime, don't drive. How'd you get here?
Somebody took me here.
All right, where are they?
They went back. He was gonna pick me up, so I gotta wait a little bit.
Oh, you have him wait. I want to make sure he's not driving.
You had a woman walk in. I think it didn't print, but she has a court date today. If I get it processed, would you be willing to see her?
No. Yes, I will see her. We always take our walk-in customers. All right. I'll see you in about a month and you see what you can accomplish in the meantime, and do not drive. Mr. Jones, would you come up to the podium? We'll take care of your matter, and then we'll have time to take as much time as we need in the next case. This is file 26213OT. You're Robert Earl Jones.
Yes, sir.
Mr. Jones, you got charged with no valid operator's license under Sturgis ordinance. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points. The matter was adjourned. The matter was adjourned to see if you could get some headway with your license. You weren't able to do that. So you had a pretrial with Mr. Timothy Reed, the Three Rivers City attorney today. This is People versus Robert Jones, 26213OT. He indicated you're simply going to plead to the charge of no valid operator's license, and I'm going to give you a fine and costs because he does not object to fine and costs only. Is that your understanding?
Yes, sir.
Anybody threaten you to get you to plead to this
No, sir.
or promise you anything?
No, sir.
All right. And Mr. Wright, some of these rights also apply to you. Do you understand that if you enter a plea here of guilty, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Rules are a little different for Mr. Wright, and we'll explain that. All right. Were you driving a car in Sturgis on February 3rd?
Yes, sir.
You do not have a valid license?
No, sir.
Where were you going?
I was taking my son to Walmart to get him a phone.
How old is he?
15.
Yeah, 15-year-old's got a phone now. And he indicated you were going to try to get squared away, but you weren't able to.
Yeah, I got to have my birth certificate. It's in Chicago, so.
How'd you get here today?
Courtney.
All right, very good. Where are you guys living now?
We had to split up so I'm living in a hotel in Sturgis and she lives in White Pigeon.
Well, I think probably it was okay to get out of that place you were at.
Yeah.
Your son has an open warrant for him.
Who?
Robert Earl Jones II. Is that your son?
No. My son's name is Solo.
No. Well, Robert Earl Jones II has an open warrant. He's 21 years old.
I have no son named Robert.
All right. You haven't paid the fine on the last one.
I thought I had that paid because I had it taken out of my wage garnishment.
All right, well, we'll figure it out. All right. $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee, $200 due as part of a payment plan. All right, Mr. Jones, you go out to the counter. We'll find out about that other ticket and put this on a payment plan
All right.
and stop driving and say hey to Courtney.
Okay. Well,
You're good to go. Go out to the court office. Everything is in such disarray. I'm not sure. Here, she can hear me. They're moving boxes and college hunk dudes are here moving stuff around and it's very chaotic. Thank you for your patience. You're Robert Norwood, right? Christopher, yes. That was Robert Jones. Christopher, right. Correct. Thank you. I saw you the other day on the video feed.
Well, you tried to, but the video was.
Yeah, I couldn't see you. I could hear you, but you were there. We set this matter for this morning. Your original attorney was Mr. Bush, worked out a plea agreement in this case, and you were placed on probation. Also present is your probation officer, Daniel Frazine. What is set for today is a hearing on your probation violation. The allegation is that you were placed on probation on October 20th of 2025 for 24 months. You failed to report on a monthly basis, failed to abstain from alcohol, failed to pay fine and costs, and failed to participate in treatment program as directed. Daniel filed this probation violation and the matter was set for an arraignment and hearing this morning. And I had the jail arraignment, as I said the other day. We met, Mr. Bush and Mr. Frazine met for quite some time this morning while we're doing other things. And we met in chambers. You've got some things you'd like me to know about this, but Mr. Bush says that you would be willing to admit certain components of this violation. Is that correct, Mr. Bush?
Yes, Your Honor.
What's Mr. Wright willing to acknowledge?
He would admit that he has not paid, that he has missed reporting, and he has not tested regularly.
Now, I went through those rights. Yours are a little different. You have a right to have a hearing, and we're ready to do one today, where it has to be proved beyond a preponderance of evidence that you violated the terms of your probation. You also could admit that you failed to report, failed to test, and failed to pay fines and costs. And if you're willing to admit to that, then we'll go on and figure out what to do as a sentence for this charge. Do you understand?
Yes, sir.
Anybody threaten you to get you to admit to this violation
No, sir.
or promise you anything?
No, sir.
And you were placed on probation. We talked about several different treatment plans, the culinary school, some other inpatient things. None of those happened. So did you fail to report to Mr. Frazine on a monthly basis?
Yeah, I went to Bear River for a month, and then got out, had some issues getting reference letters to obtain that school that we talked about. I was having trouble staying away from my mother's so that I could take care of my kids. My wife really needed me, and it just I got caught up in a lie with my police officer, and it just went downhill from there.
All right, and so then you weren't paying any fines and you weren't testing during that time?
Correct.
All right, I'll accept his admission. All right, John, let's hear from you, and then Mr. Wright wants to tell me some things, then we'll hear from Mr. Frazine. Anything you'd like me to know, Mr. Bush?
Really, he still has some retail fraud matters to take care of in this court, but he has been in jail for, I think, 9 or 10 days.
14.
I talked to him yesterday. First thing he did was apologize to me about what was said in court a few days ago. And I noticed today that he also apologized to Dan, his probation officer, since we've been in the courtroom this morning. I'm not a psychologist or substance abuse expert, but I think certainly sobriety and the time in jail has cleared his head, and he's probably in a position to make good decisions. Thank you.
Mr. Wright, we tried to accomplish some things here. Daniel spent a lot of time on this case. Once upon a time, we were all here in the same building, and Daniel would come up and see me and tell me what was going on. And we were very encouraged about the culinary program, which would have provided housing for you and your family, and you needed letters of recommendation, which I'm not sure is accurate, but we gave you one the instant we knew that you needed one. Anyway, those things didn't work out. So what would you like me to know?
Well, the culinary school needed three letters. Pivotal was supposed to write one, that fell through. Dan, yes, wrote a very nice one that I appreciate. And then I was waiting on one from a clergy member, and that one fell through. I don't have many other resources other than that to obtain the reference letters, and I was getting frustrated. And at the same time, I was being told by my mom and my wife that I needed to be around to help her with the kids, but at the same time, I couldn't be there because of probation, and the courts didn't seem to want to lift up that stipulation. And so I thought that the kids came first, so I decided to help them out rather than comply with my probation, which was a bad decision. Dan was there for me. He did nothing but good for me. I'm the one that fell through on a lot of promises that I should have kept. I'm starting to get a handle on my sobriety. Bear River was definitely a good choice. I wish it was longer. And I think the system fell through on me a little bit, but I felt I did it all on my own. I'm a new father of three little ones that scares me every day of not being able to provide or be there for them and whatnot, and then still at the same time tackle my sobriety. My mom's disabled and is taking care of my kids along with my wife, and that's not fair. I've been trying to find programs to where I could tackle my sobriety and still be a father at the same time. I haven't been able to find that program.
Paul, could you check the system and see how much credit Mr. Wright has?
They told me it was 10 days.
He says 14. I guess we'll find out.
I called the booking this, but just before coming to court.
Booking told you 10?
Yeah.
All right. Go ahead.
I am very aware of my issues and what I've been causing, the disruption in my family and in the courts. Sobriety is definitely a long road to handle. There's a lot of things that I've acknowledged within myself, my chemical imbalance. I was off my medication. I had problems getting back on my medication once I left Bear River. And I know now that I need to stay on top of that medication. It helped quite a bit in order for me to make right decisions. You know, I'm just trying to, I'm 40 years old and yes, I need to take my head out of my rear and start acting like an adult. Stop putting blame on everything else.
That's exactly the right thing, and you say it, but then you contradict it. You're right. You need to just own it and stop blaming everybody else. And those are good things to say. You mentioned some retail frauds. I don't see anything in our system. Is it another jurisdiction?
No, they have the sheets on it and they've authorized it. It's 4 separate offenses, which they're gonna, they've already authorized and pulled them into 2 retail fraud seconds charges.
Where from?
Walmart, I believe here, but our prosecutor has authorized them, or is in the process of finalizing the authorization.
Well, they haven't made it to our system yet.
No.
Okay.
So I don't believe he's been arraigned on those.
They just got
haven't-
So
they haven't even
perhaps I brought
filed-
him up and I shouldn't have. but
They
Yeah,
just
they
got the blue
knows
sheet last week.
They haven't filed the
Blue sheet.
paperwork yet, but Sarah, they're in the background. What do we have for jail credit? Yeah, that's what Daniel had. Well, we did it. I called you at your sentence at Tasmanian Devil. I didn't mean it as a necessarily an insult, but you're a spinning tornado of chaos visited on the people that you love the most, your mother, your wife, your kids. I also think there's a methamphetamine component in here. I think when you got out of Bear River, I think you got in with the wrong people. I think talk about chemical imbalance, throw methamphetamine into that mix and you're a recipe for disaster. I think in your heart, you want to do the right thing. You want to be a good dad. You want to be a good husband. You want to be a good son. But I think your family's afraid of you. I think the Tasmanian Devil, sower of chaos, scares the people around you. Don't know anything about these retail frauds because the prosecutor hasn't actually filed them yet. So they're coming. But I'd try to deal with them right now if I could. This was an unusual sentence. I ordered 93 days and deferred all 93 days. And the wheels have fallen off. I'm going to get off your back. Probation is revoked. No waive all the fines and costs. 93 days, credit 10, leaving 83 days to serve. You'll get good time credit. 93 days is about 77 days minus 15. We'll find out about these new charges when they come. Pivotal and Lauren are at the jail. Maybe they can work on the next placement. But this didn't work. Daniel said it. You need some forced clean time. Maybe John said it. Get squared away. I'd like to see you get your goals of being a supportive father, but you're not there right now. So you can go with the court officer. You're off probation. When the prosecutor files these new 4 retail fraud charges, I guess we'll deal with those as they come. I don't know anything about them, but this matter's done. You're good to go, Mr. Wright. Maybe you'll be some sort of a trustee. All right, thank you.
Case number 25-01285FY, People State of Michigan versus Hussein Fawaz.
49 on behalf of the people.
Good morning, Your Honor. Roger Quinn on behalf of Mr. Fawaz, case 62269. Mr. Fawaz, can you please take the record? Mr. Fawaz?
Okay. Today is the date scheduled for a preliminary examination. And let's see, it says motion hearing 2.
Yes, and we began the motion hearing last time. We also began the preliminary exam.
That's what I thought.
Before, I believe we've completed the direct exam of the people's first witness.
Yeah.
And we should then come back and put that.
Do we have
Your Honor, with all due respect, I did notify the prosecutor last week. I did receive a letter because I think we talked about doing a FOIA, asked me to do a FOIA request, which I did to the Dearborn city. I filed it. They responded on March 31st that they need till April 16th to get all the information. So I would respectfully ask for the date of after April 16th to finish up to get the information. I do have of the letter from Dearborn.
Okay.
Explain to me, Judge.
Let me see.
What we want a copy of it.
Yeah, let me see what you got.
And Your Honor, I would object to that, being that this is a preliminary exam. Included with the, most of the testimony, obviously it's people's burden just to show that a crime of likely occurred, that we're kind of as likely the person that did it. This isn't a trial. Anything from FOIA would at most create a question of fact.
Your contested information goes into specific information on the police report, and we agreed that prosecutor said she's not gonna get me the information. She said, if you want the information you want for this exam, you FOIA it. I did FOIA it. They responded, they needed motion. And it's key information within the police reports that the tracking of the truck, the previous, I guess how they came to that truck to identify as the potential, what investigation they were doing on it. I did my request and I filed it. That's the response from the court judge. I asked for I gave the specifics on the license plates of the truck. They did mention in their report there were previous investigations on this. I don't believe my client was involved in any of it, but that's what they're focusing on to get my client involved. And I asked for that information, Judge. I have a copy of my FOIA request. We would ask for short adjournment as they put in their past April 16th.
I see that.
Yeah.
So,
17th, 18th, fine, as long as I get the information.
Your Honor, may I respond?
yeah, let me ask a question. Are you saying that you would like this information and it bears on how you're gonna cross-examine the
Yes.
witness?
I need the information, especially on what he mentioned in his police report about the previous investigation targeting this truck and these parties, I guess. I haven't seen the response. I also wanted the logs of what they used, but they used apparently their own clothes, their own cars, but somehow they used department radios. I wanted to see if they used their cell phone. I want to see what was used on that day and what the communication was, how they targeted that truck. I did ask for some also financial
Do
information.
you think this goes to what, the issue of what probable cause?
Yes, absolutely. They didn't, no way in the videos did my client appear on all the, that they at least turned over to. My client's not in any of those videos until the end when he stopped in the truck, but I haven't seen any videos, any dash cams or anything to show that my client was anywhere there at the time.
Mhm.
And we have we're gonna put on a defense that my client was an alibi defense, someplace at another location. We have witnesses coming in for that. But in any case, I want to see how they came to target my client. Nowhere do I see him in the truck. Nowhere do I see him on transporting anything. And, so I asked for that information in my FOIA question.
Okay.
And I did tell the prosecutor I would do it. She said, go ahead, do it.
I don't mind if he files a FOIA request, Your Honor. I'm objecting to the adjournment of the preliminary exam. We've already heard from one witness. He testified that he saw a black Ram truck outside a tobacco wholesaler, that there was also a white Jeep that was loading up cases of presumably cigarettes into the white Jeep from the tobacco wholesaler. The task force followed the black Ram, which was following the white Jeep, to the Costco Business Center here in Southfield. The task force deployed a drone. From the drone footage, they saw somebody get out of the passenger side of the black Ram, bust out the window of the white Jeep, move some boxes from the white Jeep into the black Ram, and then take off at a high rate of speed. We also had testimony that the task force continued to follow the black Ram to Detroit. where the occupants of the vehicle got out of the black Ram and got into a gold Yukon, also moving those boxes that were presumably the same boxes that were taken from the white Jeep. My next witness will testify, I'm still responding. My next, and that officer, Corporal Carable, did identify the defendant as being eventually stopped in regards to this case. My next witness will testify that he was actually the officer that conducted the traffic stop, that the defendant was present in the vehicle, as were the cases of cigarettes that matched the description and the value given by the owner of the white Jeep who had contacted Southfield Police. As the court and defense counsel is well aware, the purpose of the preliminary exam is for the people to show that there is probable cause to believe that a crime occurred and probable cause to believe the defendant is the person who likely committed it. I believe we've already shown that. I'm going to tie up the testimony today just with the traffic stop. This is not a trial. Any question of fact would be resolved in favor of the people. Mr. Farina would have probably a year, if not more, in circuit court to prepare for a trial based on the trial schedules of the judges in the Sixth Circuit. I'm asking the court that we continue. I have two Dearborn police officers here today, Corporal Carabo, who needs to be cross-examined, and Corporal Fox, who's conducted the traffic stop. It is an inconvenience for them, Judge, to be frank, to come back to Southfield on a different date. They're here, they're ready to testify. I can wrap this up in 10 minutes, excluding any cross-exam.
Well,
If I may, she left out one key element.
Well, what-
The license plate was blocked out. According to the police report, there was a black marking over the license plate. So if you can't see the license plate, how do you know that my client, if it's his truck? It's not even his truck. It's not in his name. It's in the name of a actual individual who sued the city of Dearborn and recovered $125 million. So I want to see what kind of targeting they were doing on this truck and who they were actually targeting. Because I don't see any evidence my client, who runs an automotive business, repair business, has a CPL, is going to be involved in stealing cigarettes. So I asked for the documentation and she agreed that I would do the FOIA request. That's a federal statute. If I do the FOIA request and I'm requesting documentation and it's been agreed by you and I'm waiting for it and they tell me I didn't tell them, they tell me they need time to get it fixed provided for me, and they don't have an obligation to turn over the discovery, the FOIA law is not going to be superseded by her claiming that I've got two detectives when I notified her last week that I would be asking for an adjournment, why I would be asking for an adjournment. And I called her on Monday, I received no response call from her, from counselor, no disrespect, I'm sorry. But in other words, this is information that's needed, it's a FOIA request. They've asked for an extension to honor the FOIA request. We agreed on a FOIA request that I would do. I did it. Now she wants to back off and say, no, you don't get the information from FOIA. People think that how the preliminary exams are just rubber stamp and take care of it in circuit court. No, probable cause is an important issue. And what just standing up and saying it, and I can't cross-examine that with other information to challenge his credibility, is unfair for my client and prejudices my client here.
Well, this is why I asked you the question first on. I don't think anybody is questioning your right to get the FOIA information, to do the request, to get the information. I mean, that's pretty clear. It's pretty clear. Whenever you asked them for it, because we were back here March, I think the 6th, and their letters from March 31st saying that they didn't get it till March 25th and that they needed 10 business days, which would be April the 16th.
I understand March 24th, Judge. I personally walked it in rather than mailing it and risking it getting lost in the mail. I hand delivered it in the morning.
Yeah.
And they didn't say they can't do it. They said they need more time.
Right.
I know what the information I asked for. I know that the police records and
Why was it 2 weeks after we were here? Because if you had walked it in there the next week, you'd have had it.
Well, my request is pretty thorough what information I needed that I didn't get, especially for the preliminary exam.
Okay.
Yeah, so response to the license plate argument, just very.
Well, okay. So my question really is I don't believe in the rubber stamping. I've done this job on the other side, so I do understand that it's her burden to show what she has, but you can test that evidence and you can cross-examine and it may create a question of fact, but you're entitled to do that. And that part I get. But my question is, does this really go to probable cause?
It goes to the credibility of the witness, which goes to the investigation, which goes to probable cause.
Okay.
Because like I said, none of the videos I see my client in at all.
Mhm.
And all we have is his testimony and these officers' testimony after the fact, after they stopped the vehicle hours later. So this information is crucial for my cross-examination on this officer.
And what I'm hearing you say is you don't understand how your client came into it before he was in the vehicle. What information did they have at all to even connect him to anything that allegedly happened here with the stick?
Chase, this was we saw this break-in, this was an investigation and targeting a certain truck and certain individuals.
Mhm.
And I want to see how my client got pulled into all this and see what information they have.
And you're on
I'm
already
not
testimony.
I'm not trying to, I'm talking, please, Counselor. I'm not trying to delay. I'm ready to fight this case, and I've been shown, we let the witness testify already, the start. So we're not trying to delay this for delay. I'm asking for 10 days like they asked for, based on what their request is, so I can prepare. And I have some questions for the credibility of this witness that's very important. And if he's found incredible, where's their probable cause? If this witness is proven incredible and as if this information is wrong based on his police report,
It could happen.
And Your Honor,
where's the probable cause? They didn't have my client anywhere on videos doing anything. I saw the drone. My client's not in the drone video.
Okay.
Your Honor,
I'm asking.
what Mr. Farina is talking about, if he is able to.
Are you still talking, Mr. Farina? Go ahead.
Thank you, Judge. I'm asking for a date. I said April 16th, after April 16th, that's the date they gave. April 17th or.
I get you.
So nothing.
No, what do you want to say? Ms. Rose, no.
Just responding to the license plate, Your Honor, we've had testimony that the license plate was only blocked in the Costco parking lot. That it was not blocked the entire time that they were following the vehicle. We've also had testimony that the eye always had the black Ram from the time it left the wholesaler until the time it arrived in the Costco business parking lot. So I don't understand how anything about the license plate would not just create a question of fact. What Mr. Farina is talking about regarding wanting to test the witness's credibility, I totally understand. And I'm not asking this court to rubber stamp anything. It's a very important step in the process. However, when we elicit testimony today, that testimony will be sworn under oath. We'll produce a transcript that I'm sure Mr. Farina will order. And if it comes to light that the witness was not giving truthful testimony, I'm sure Mr. Farina will write a very persuasive motion to quash the bind-over based on that information. And I've seen bind-overs quashed for that very purpose, Your Honor.
Well, why do we need to go there?
And Judge, and in response to her license plate, he testified that he followed the truck all the way. The truck never stopped until it parked. He mentioned nothing about them getting out, unless they had a way of getting out of the truck and taking off the light.
Yeah, I kind of remember. I don't remember them saying anybody got out of the truck.
So how did they take off the thing blocking the license plate? And how do we know? I mean, there's other questions I'll be asking. I don't want to go into my strategy, but I think that information is necessary. I respectfully request. I notified the prosecutor a week ago. I didn't hear any response from her. I called her Monday morning. I got no response from her.
She was out of the office.
No, she was back Monday. I believe subject. I believe she was back Monday, so I left messages again. I sent emails to her and stuff, but nothing that I explained why we need it. I imagine she would check Dearborn to verify that they did put together the document that says that they needed time.
What Mr. Farina is requesting is not part of the people's evidence at this point. I have no intention of eliciting any testimony about it. I'm asking the court that we be able to proceed with the preliminary exam today. We set aside a lot of time to do this. The Dearborn officers are here. There's no reason to delay this matter any further because Mr. Farina doesn't even know he's been fined with the photo.
Well, yeah, that's true. He doesn't know. But how does it hurt your argument, Mr. Farina, if you do get the documentation later, you see something in it, you obviously could do a motion to quash at circuit court, or you've got it for trial. So how does that really prejudice your client in any major way?
Your Honor,
If you didn't have it for the
let the
exam.
prosecutor dictate my case or what I will do or what my options are.
Mhm.
Okay? That's the first thing. The second thing is this witness, the credibility of witness, if I can show from the documentation I expect to find that certain things were used and not turned over to us, like for instance, the phones. Okay, they do everything else, Judge. They use their own clothes, they use their own cars, But somehow they go and then they get radios from the Dearborn Police. Everything else is their own private equipment. And I'm thinking they use their own cell phones to be communicating. And I want to know why they targeted my client, why they targeted this truck. They said there were previous investigations, but nothing's been turned over. Counselor said she doesn't have to turn over discovery to me. Do a FOIA. That's what I did. And when I get the FOIA information, then I can properly finish the cross-examination, my beginning cross-examination of this witness. We didn't delay anything. We started the preliminary exam.
Yeah, I know.
So we're not holding it up, but I do need that information, and my client needs that information to properly cross-examine this witness, especially as to credibility, and the next witness, about as to credibility. Judge.
All right. Well, I'm going to go ahead and give the adjournment. I'm inclined to do so. I think it's fair under the circumstance. I know the prosecution wants to get this over. The court actually wants to get it over too. We did block off some time today to do just this. We're probably not going to have any time until a couple more weeks into maybe into the next month. But I think it's fair for the defense to be able to explore this issue if it goes directly to probable cause, which he's making the argument that it may very well be. And he may find nothing. I don't know. We don't know what you're going to find, but we'll give you the opportunity to see and cross-examine the witnesses. You can deal with their credibility. And if it gets that far, maybe you get a dismissal at this level. But if it doesn't, she's already made what she thinks is enough evidence to bind the matter over at this juncture. And then you're still going to be dealing with it at circuit court at that point. But I'll give you the chair.
Your Honor, I just want to correct the record that I never told Mr. Farina that the people don't have to turn over evidence. I just suggested that I don't have to turn over evidence of the nature of what he was searching.
Searching for it, yeah.
The people have.
That's understood.
Everything that we have at the present time.
Yeah.
I'm still in communication with the Dearborn Police Department to make sure there's nothing else. If and when I receive anything else, I would give it to Mr. Farina.
Right. Yeah, I think we understand that because this is sort of going into really deep into not just this case, but potentially other matters that could be under investigation in the city of Dearborn that somehow relate to this. So no, you would not have had to turn that over. And I think he understood that. So, all right. What date can we get this in?
I'm going to put my witnesses in, Your Honor. So
Yeah.
that they can- That's okay.
Mm-hmm. What do you think you have?
Actually, I think it was April 21st at 10.
Oh, good.
The jury trial date, but we don't have a jury trial.
Oh, great. Well, let's see if she can do that.
I also asked them when I sent a response to the judge to give me the finances because I don't want anything delayed.
The date we have is April the 21st, so quicker than we thought, at 10. So, yeah,
It's
is that,
available April the 21st at 10 o'clock.
Uh,
That date unfortunately does not work for Purple Fox.
Court's available April 30th at 10.
That's a good date, Judge.
okay, then it'll be April 30th.
We continue the subpoenas to the judge.
Yes, so all subpoenas will be continued to that date. We will be going on that date.
Thank you.
Thank
I'll
you,
send
Judge.
those advice.
Mine is continued.
Thank you.
And let's give you your letter back.
I have other stuff. Good job.
Okay, thank you.
Ready on purpose, Judge.
Oh, wait a minute. Mr. Farina,
Oh, hold on, Judge.
Mr. Farina, I got some no-shows I just noticed. Do we go through these? They're from March the 6th. He was in court March the 6th, so that could probably be why.
Been about 4 months, so he's on medications for that, auto shop. I remember that, and he did send it to them as well, restriction that is on.
Oh, for the positive drug test on the 14th. Okay. Yeah, they don't note it now, but you gave them your prescription. Okay. All right, then the vine is definitely continued.
Thank you.
You're all set.
Thank you.
This is case number 24S 00101 SM. people of the state of Michigan versus Mallory Walker.
Morning, Mayor. Brittany Rose on behalf of the people. Morning, any good looking on behalf of Mr. Mallory Walker.
Okay, good morning, Ms. McGee, Mr. Walker. And Mr. Walker, you're here for a probation violation hearing. This would be on one kind of domestic violence. So the maximum penalty on that is up to 93 days in jail. You definitely have a right to have a full violation hearing with your counsel here representing you. And of course, at that hearing, the burden of proving the violation would be on the prosecutor to prove by what we call the preponderance of the evidence, or basically more likely than not, that you are in violation in the manner claimed. So if we have a hearing and we find you guilty, or if you waive the hearing to plead guilty, that's when penalties would come into play. You understand that? All right, so the allegation here goes back to March the 10th, 2026. At which time on this violation, it was alleged you failed to refrain from consuming alcohol. All right, so how would he like to proceed on that?
On that, we've got to review what the allegation is. Today is the things are for the violation. Is that what this is definitely?
No, I mean, I don't think anybody knew he wanted actual hearing.
No, he doesn't. He wants to plead guilty with the next one.
All right. I think it was the date of February 21st. They're claiming that he had positive ETG and the confirmation test was positive as well. So you wish to waive the right to the hearing and now plead guilty, sir? Anybody force you, threaten you, make you give up your right to the hearing? You been promised anything to do so? And are you pleading guilty to this violation freely and voluntarily after talking to your lawyer? All right, so it's true that you tested positive for alcohol on May 21st, 2026. Excuse me, February 21st, 2026. All right, and that's sufficient basis, and I will accept the plea. In finding that it is freely, understandably, voluntarily, accurately, and knowingly made. Okay, this is the second violation. The first violation was back December of last year, failing to report, failing to complete the screens, failing to attend the Redeem program. And it looks like when we dealt with that violation, and he's also on spouse abuse status, by the way. We gave him, let's see what we gave him. Well, I revoked the 769 for a status back then. That was January 9th of this year. I extended his probation 11 months, all the terms and conditions. Gave him 90 days, credit for one, suspend 89 days if he was in compliance. And I made a note, any violation, defendant is to do the 89 days.
If he's not,
Sure.
my client could probably explain it better than I could, but he is in a remission status for a health condition.
Or what?
He's in remission for a health condition,
Oh. Mm-hmm.
but his body does have a lot of issues with. Okay, I believe his immune system is compromised. He has a lot of issues with fighting off colds and that kind of thing. So he did catch a cold. He did take medication. Tea, his fiance is here for today to support the fact that she was also sick. She made tea. She put a little something in her tea. He drank the tea. So he is admitting that he refrained from alcohol, but he was actually sick and drinking tea that had alcohol in it. Unknowingly.
Really? I don't believe that. That's laughable. You can't drink some tea and not know it's got alcohol in it. Tea is pretty light. You could smell alcohol in tea.
At the time, my nose and taste buds were gone, so I couldn't smell nor could I taste.
Sir, you know what? When it's, here's what I'm known for. Giving a lot of breaks.
You have been very, very.
But at some point, when I tell you this and I write it down, I mean what I say, because I said what I meant. And I meant it. So it was incumbent upon you to figure out how you were going to not drink. To tell your girlfriend, don't put no alcohol in nothing for me, because I can't drink it. That's your fault. That's not a good explanation. I don't know why people do that anyway, because it don't cure nothing. It doesn't cure whatever you got. It didn't fix that. Maybe made you go to sleep, but that's about it. That's some old wise tale that people just do for doing sake. When you on probation, you got to walk the line. It's got to be a straight line. You know, it's like anything. You a grown man. You got to take charge of your life. This is your life. You take charge of it. You can't let outside forces come in and give you something and you don't question it. When you're on this, you can do that all you want when there's nothing going on and you ain't not under any supervision. You want to trust what somebody gives you, great. Because you don't know what's in it. But you trust her, I'm assuming, so you did. Does she know you're not supposed to drink? So then why would she give you that?
It was a total mistake. So
How was that a mistake? But she made some tea and she put the stuff in the tea. So you picked up her tea.
I picked up her tea instead of my tea. It was a total mistake. I know it sounds, I know you say
Very contrived.
I totally understand that. I'm apologizing to the courts and you also. It's not something that I'm.
So you got 2 cups of tea sitting there and you just pick up hers instead of yours.
It was because they were prepared servants. So it was an honest mistake.
So where were you when this was going on?
Where was I?
Yeah, where
I
was
was in the comfort of my home. It was on the side. It was Saturday.
And there was a numerous cups of tea made with some alcohol in it.
Well, no, that's not. And she can also attest to this. The cups that were for me were not supposed to have alcohol in it. It was just supposed
So how would you get a cup with alcohol?
The cup that I got with alcohol, it was mixed up based on her mixing the cups up. It was not my fault. It was something that happened just miscellaneously, and it wasn't something.
Oh, but sure they cost you, didn't they?
Yeah, but what I'm here to say today is it's not something that, I did deliberately. I take you seriously and I truly apologize. I'm not in a position to even be in front of you embarrassing myself like this. And it's very embarrassing. And what I would further like to say is you gave me a chance and you did give me a chance and I appreciate you for that chance. But what I'm here to say in addition to that is it was an honest mistake that I'm totally embarrassed about. Totally embarrassed about. I have other qualifications that keep me from actually drinking. I take very, very hard into the compliance of what you said in front of me because I realize that this has been an ongoing matter and I want to get it behind me just like you. But I have been struggling ever since. And I'm trying to get out of this struggle. I don't want to keep losing because that is not my character, nor my persona as a person.
And I thought, if I may, I don't know if we're at the sentencing phase yet.
You want to speak first? I do want to say something, but I'll defer to you, Ms. McGee. Would you like to say something?
What's her girlfriend's name? Mrs. Hall. Yeah, go ahead.
Oh, thank you. I just want the court to consider that he was, at least from the register of actions that I received, compliant for a year on probation. It doesn't look like he had a lot of issues. He did have that violation. It did not include any positive screens for alcohol. And I understand that this is a domestic violence charge, and that his status was already, his 769 status was already revoked. I did not see anything regarding alcohol, but he did tell me that.
Last time was failure to complete the alcohol screen, so we don't know if he drank before.
That was, and remember, for my conversation with you, I was explaining to you, I said, I'm working a lot, I'm catching up, I'm trying to get out of this struggle. And based on me missing those screens, every time I've missed them, it was due to the work. And I even asked you back in November the 19th, when I seen you, I said, Your Honor, I'm just asking if you would just please grant me this so that I won't have to come in front of you and look like this. And your response to me was, well, I have to see what I have to do. So I had to see what you had to do, but I don't want to be in this situation looking bad in front of you and potentially causing myself more mischief unnecessarily. I work and go home.
I don't know what you want me to do. I had nothing to do with the hot toddy tea, you getting mixed up, you drinking it. What do you expect me to do? You can say you don't want to look stupid. Well, okay.
I can't say what I expect you to do. I can just only eat. Okay. What I expect you to do.
What you would like.
What I expect for you to do is to help in the circumstances like I've watched you help people.
And I've done that.
Okay. So I'm asking for some more help because I'm not in the position to actually have to sit down and do 89 days. I have a mortgage. I have other responsibilities that I do not want to lose out on. I have, ever since that you sentenced me to what you sentenced me the past time I was in front of you.
You mean just January this year?
Just January this year. I've been keeping account to my classes and things of that sort. I have discovered some things here today that I was unaware of, but I take you serious. I take you a whole lot serious because you told me out your mouth that I wouldn't finish. And I told you, I said, hey, I don't want you to believe that. I would rather come prove you wrong. So I don't want you to feel like because I'm here standing and pleading in front of you today that I don't take you serious. I actually take you serious. And I don't want to be in a position that's going to make my life even worse from a circumstance that was typically beyond my control. And it was a mistake. And I understand where you're coming from today. I don't want you to feel like I don't understand, but I'm begging and pleading for you to just give me a chance. I don't want to be in front of you. I don't want to ever have to come back in front of you. And I would like to continue. My money is paid downstairs. My money is paid completely off downstairs. I'm doing what I can with what I have, and I'm trying to do more. So I only can continue to do that because all it takes is one break. And that's what I've been striving for ever since I've been in front of your face. At all times.
To add to what he's saying about taking the court very seriously, as he stated, he did complete, or he has paid all of his fines and costs. He's enrolled in the program HEAL. What he just found out yesterday is that he owes $150 with that program. He was not aware of that if he would have paid it. And he also found out today that the probation department is saying that he missed or he had 4 absences in that program. He has notes and dates of going.
Notes and I have screenshots of when I actually attend this class. So my thing is to get to Miss Kate and hey, can we work this out? Because I'm in front of Miss Johnson. Miss Johnson is not playing. I don't have time to come in front of you and look bad, no more than what I've already had when you've given me chance after chance after chance. And that's not something that I want to continue to do. I've been in compliance. I take compliance very serious because the overall objective is to get off. I understand everything that you're saying. And you are 100% right. And I'm not taking you for granted for that. I'm just asking you to please have some grace on me today with this. I'm going to continue to go to my classes every day. I even go to extra classes. They have mentor meetups. Mentor meetups are defined as classes that you can take if you have an absence or something of that sort, within this 7 months, I have the opportunity to attend at least 7 of them to actually add 7 additional absences if I have any absences to my actual weeks. This program is totally different from the last program that I had. It's totally different. It's way more easygoing. It's more opportunities for days that you can get in and out of the class, and they offer this mentor meetup. So if you're behind on your work or anything of that sort, you sit in front of people and you go to these mentors and they actually help you with the work. Work is not complicated for me. That's not the problem. I go every Thursday. Thursday works for me from 8 to 10. I've scheduled my stuff around that so it can work. I've scheduled my job around it. I've scheduled my entire life. In addition, when this happened, I got a promotion from my job. My actual boss went and bought a whole nother truck. I have a CDL. He went and bought a whole nother truck because he procured a contract that he's putting me on an assignment based on the way that I work and how I do my due diligence at work. I'm working around the clock to try to catch up. So and I was able to pay the balance to sit in front of you to say, hey, this is paid. I'm trying to look as best as I can under the worst conditions. And that's just the bottom.
What do you want to say?
Your Honor, I don't think the court should find the defendant's reason credible for a couple of reasons. First, with regard to the T, the amount of nanograms from both ETG being 6,143 nanograms and ETS being 2,154 nanograms suggests that the defendant would have been inebriated from the T, would have had the opportunity to come forward, talk to probation, say, I was drugged with this T, what do I do? You know, there's something that happened here. No, he's coming forth with this explanation once he was caught and he's before the court. Secondly, Your Honor, he just stated that he has attended 7 mentor meetups. Well, the letter that we received or that Ms. Turner received from Chair on Services says that he attended 1 mentor meetup. It says that he attended a total of 6 sessions, had 4 absences, and cornerstones the second phase of the program. He attended 1 mentor meetup. He has an outstanding balance of $150. He paid for his book, but he didn't even arrange to pick it up or to have it shipped. And finally, Your Honor, I'll just remind the court that when we were here on January 9th, the court did sentence the defendant to 90 days in the Oakland County Jail with 1 day suspended or with credit for 1 day and then suspended that sentence. And your words, Your Honor, you said there needed to be 100% compliance with the HEAL program through the remainder of the probation, which you extended to 11 months. And that was the time when you revoked the 7694A status. There has not been 100% compliance here. That jail sentence that you gave the defendant on January 9th still stands. It's just whether the court is satisfied that it should continue to be suspended. Thank you.
I'll just respond to what the prosecutor is saying. I believe my client said that he had the opportunity going forward to attend 7 meetups. He has met once with the mentor meetup. Additionally, my client pulled some information about the amount of alcohol that was actually consumed from the Wiley online library, and it indicates that 6143 nanograms is an extremely low amount of alcohol, and it amounts to about 0.0006% of blood alcohol content. He did let me know that. I told him a positive is a positive, but in light of what the prosecutor is saying, that he would have been drunk or inebriated, it doesn't appear that science agrees with that. This is not anything that's confirmed. I know this is not a hearing, so I don't have a doctor or a scientist to verify this, but this is something that he got from the Wiley online library. I don't know if the court wants to see it, but apparently it's a very low amount.
Your Honor, it's been my experience, and I know it's been the court's experience for many, many years that is just not true. We've had expert testimony regarding the levels of ETS. I know most recently from our most recent hearing that the cutoff for an ETS is 100 nanograms. And so this is over 2,000 nanograms past the cutoff. There's also been testimony that we've had in the past that a certain amount of ETS or ETG doesn't translate to a bodily alcohol content readily because it depends on the size of the person, the gender of the person, and a number of other factors. I don't know where this came from. It's not coming from an expert and it's not credible.
I don't know, I don't have an expert for this, Your Honor. If we had gone to a hearing, then maybe I could have found an expert to testify before the court, but my client wanted to plead guilty because he was positive.
Well, I don't know what to tell him. It's a lot at risk here. Yeah. 6,143 nanograms is well over for ETG. I think the cutoff is 500. That's where if you just had been exposed to some amount, a small amount through a mouthwash or hand sanitizers or some other little things. This is 5, 6, 7, 8 times more than that. It's 6,000.
Like I said, I totally understand that, and in response to what the prosecution has said, we have seen this, and it wasn't, something tested, but in turn, like I'm stating, and this is the truth. This is not something that has to be proven. I am somebody who has a health condition that is, this type of stuff is not conducive to my body. I've been dealing with my symptoms I have to deal with it for the rest of my life. In terms also to me having a CDL license, that's not applicable with the CDL license. My CDL license can be revoked and snatched from me, which will alter my life. I've been through enough.
It could be revoked and snatched for what?
Drink
at all.
It can get snatched.
So you're not, whether you're driving or not.
Because this is the thing, you have a drug or something. If you take a drug or something and you test positive in a drug or something, your license is on the line. So I don't have any room to gamble with my life.
That's really interesting how you tested positive anyway.
Absolutely correct.
So that's could have been on the line. I guess not, because I guess they didn't question you during the time you drank this tea. But you're making an argument that, yep, I got these qualifications and I can't be doing this stuff because it's going to affect my license, and I got this great job and this and that. No, but you did do it. And you did have it in your system. So how's that argument fly? I got health condition. I'm not supposed to be drinking, but okay. I don't even know how you get the teas mixed up. I'm still stuck on that. I know what alcohol smells like. It's not hard to smell. The kind of things I think they put in tea, I think you can smell them fairly easily. So I'm not sure how you got to the point of mixing it up, putting it up to your mouth, and then drinking it without smelling anything. But you said nose is stopped up. I just don't know. And now I have to see, this is already a sentence. This is already done. I gave it to you last January. So now you want me to not enforce it based upon a bunch of reasons that I'm not sure I get. I fully appreciate some of the things you're saying about your job status and this and that. But you don't know how many people I see around here that do things that I don't understand under the circumstances why they would even do it. You could be one of them. Yeah, I just drank it. I got it because that's what I wanted to do. And yeah, I put this on the line, but I have a reasonable explanation that she should believe. I don't really necessarily believe it. I do this sentence, this cuts you totally out of the probation. You be done. You don't have to do nothing else. It just all be over. And when do you work?
Every single day. I'll be looking at Sunday based on how.
Mhm. And so when you drive locally?
Yes, my first assignment was like taking, my, loads up north. That's how I was able, that's why I was able, having a situation that I've had before. So now it's, a new assignment where I'm either gonna be, maybe like Caledonia, Michigan, somewhere outside of Grand Rapids. And then also around Lansing or Fowlerville area, based on the contract.
Well, you're not gonna be able to go to jail and do that. Even with work release, because you gotta come back home, back to the jail every day. So you can't go to Grand Rapids and just be over there and come back the next day. But those options don't work for you. And I really don't want to take no more chances on you because this is just April. We're just here in January. Barely 3 months. Here you come back.
Yeah, I know that you don't want to take no more chances on me, but
Blame for what? Told you last time. And it sounds like, even though she didn't violate you for it, it sounds like something's going on with the HEAL program. I didn't even understand what's going on there.
I would immediately get on it immediately to get the correction. Because it's just a mix up somewhere. I have all my dates written down and also other proof. Cause I get on Zoom.
This letter was from March report. I sent you to them in January. Why would you not have picked up your book yet?
As far as the book concerned, once I paid for the book, they revised the book. As soon as I paid for it, they revised it. From the Redeem program and the HEAL program typically has some of the same information in it. But due to the revision, that actual book that I paid for, it's a mix up somewhere. It's in my email. I asked them to send me the book. The book never was sent. And then she had, right in the duration of time, she revised the book. So I actually explained to Miss Darlene, I said, I got a book from my past class and it sounds like everything is the same. And she said, okay, well, you can use this book based on until you get your new book. Now, once the revision of the new book came out, it actually wasn't picked up. She actually messaged me last night and said, how do you want your book? Do you want it sent or you want it picked up? I said, well, I can pick it up because I wasn't sent the first book.
Okay. Send it to the court. You're going to do 89 days in jail. I'm going to suspend 79 of those days if you are in compliance, which means you're going to go now for 10 days. Don't come back here. I don't care what cockamamie story you got. You're going to do the 79 days. I don't care what she gave you and you picked up by mistake. You're going to do 79 days. This at least will give you a chance to possibly keep your job. $100 in violation costs, $150 attorney fee, and you will pay everything else that you owe and continue all terms and conditions. So that's 10 days. You better figure out what you're gonna do with your job for 10 days. That's it. I believe that concluding this matter.
Okay, all right, Mr. Davis, just have a seat for a couple moments. We're on the record in the matter of the state of Michigan versus LaShawn Wells, 241642.
Attorney Corey Westmoreland, appearing on behalf of Mr. Wells. Mr. Wells, would you please state your full name for the record? LaShawn Williams.
All right, good morning, sir. Please keep your hands out of your pockets. And so today is the date scheduled for the jail review in this matter. The court will note that you were here on March 24th. We held the jail review. You indicated you were paying your balance that day. And you were to clear your warrant. We moved it to today. You did not make a payment at all on March 24th. You were here in person. Weren't you here in person? I'm pretty sure you're here in person because you handed me some papers. Because, well, actually, no, you did not. You had your mom email the paychecks and the pay stubs because you did not bring those in yourself.
Right.
Then you said you were paying your balance that day. You didn't even stop and make a payment, not even a payment. You not alone did you not pay your balance. You didn't even make a payment, sir.
I didn't make a payment. What I'm lost.
On your balance of $600. Actually, you were to pay. When did you pay it, sir?
7.
Yesterday?
Yes.
You were to pay it on March 24th. I'm really done, sir, with you just thinking you're doing everything on your own time. You were to make a payment. You said you were paying your balance in full on March 24th. You didn't even stop and make a payment. Why not?
I thought I could have paid you online, and I didn't know I didn't have to pay it that exact day.
At what point did I say you don't have to pay it today? Pay balance today. That means that day, the same day. Did you clear up your warrant?
Yes.
When did you do that?
Yesterday.
Counsel? What are you asking of the court?
Your Honor, at this point, he is working at DTLR. He did clear up his warrant. He could pay off his costs and fines. I think at this point, I'm not really sure why you'd want to keep him around here any longer. So I'd be asking just to release him from court oversight.
Other than perhaps to teach Mr. Wells a lesson in responsibility and accountability, and that you don't do things on your own time, sir. Do you know how many times you've been back here? This court's allowed you to get it together. Do you know how many times, sir?
Yes, I understand.
Yes, what do you understand?
So do you know how many times? I said, yes, I understand.
Okay, how many times have you been here, sir?
At least 5 or 6 times.
Do you like coming here?
No. Capital P's.
Okay, great. Great. Then why don't you do things at the time that you say you're going to do it, or the time that this court orders you to do it? It seems to be a theme during your entire time that you've been here, sir. What if your payroll person for your job didn't submit your information timely and you didn't get your paycheck on time? That would be a problem, wouldn't it?
Yes, ma'am.
Right. So when there is a time that is set for something to be done, get it done within that time, sir.
Yes.
Stop just doing things on your own time frame. How many hours a week are you working, sir? You still working the 20 hours?
Yeah.
Did you start applying somewhere else?
Yes.
Where?
the airport. Rails, Bucharest.
Okay. You need another job, so you have, number one, it helps you earn more money, but number two, right, you're working what, 4 to 8? You have plenty of time to work another job, sir, so that you can stay out of trouble. The court's going to cancel the jail review. Have a good day. Good luck to you, sir.
Thank you, Judge.
All right, let's go on the record in the matter of the City of Wyandotte versus Evelyn Cook, 26390.
Ready, Your Honor.
Look, please unmute. And just remember, when you're slamming that stuff down, it goes right in the microphone, which goes right into Ally's ears.
Sorry.
Okay, so counsel, try again, your appearance, please.
Yes, Your Honor, Neil LeBlanc here on behalf of Evelyn Cook. Evelyn Cook joins us from the Wayne County Jail, I believe. Ms. Cook, can you hear us? Please state your name.
Yes, I am Evelyn Cook from Wayne County Jail.
All right, and so counsel, as to the pretrial.
Yes, Your Honor. Review this, back to this case with the city attorney and well, Ms. Cook. She gave me some of the background and the circumstance, how she wanted where she is today. She's willing to accept responsibility for the, as charged, that is to say, guilty to the misdemeanor count and possession of, controlled substance. Is that correct, Ms. Cook?
Yes, that's right.
All right, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth.
I do.
All right, ma'am, you heard the plea that was placed on the record. As to the charge of possession of controlled substance, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering in your plea that you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea, whether in this court, any
Yes.
other court or administrative agency.
I do. Yes.
And knowing all of that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into the plea?
No. No, ma'am.
Any immigration issues?
No.
Counsel, if you can please audio your client.
Yes, I will. Ms. Cook, you're in the city of Wyandotte on or about the 24th of March of this year.
Yes.
And that was 14 days by your count, is that correct?
Correct.
You've been in Wayne County Jail since that date?
No, I have not been able to make bail, no.
So you were taken into custody on the 24th, correct?
Yes.
Okay, thank you. And on that date and time in Wyandotte, you had an interaction with a Wyandotte police officer, is that true?
Yes.
And at that time, that officer had found in your possession a small bag of a small quantity of what tested out to be methamphetamine, is that correct?
Yeah, I handed it to him.
And you do not have a prescription for that?
No, I found it in the garbage in the bathroom and at the house I'm renting, yes. I don't have a prescription for that.
And Ms. Cook, if I may, we had a discussion before you agreed to plead today, is that correct?
Yes.
And we discussed the fact that you have a right to go to trial on this and that you'd be waiving your right to trial. You understand that, don't you?
I do.
You understand that before going to trial that I would have the ability to get what's called discovery materials. That would be body camera, drug tests, et cetera, and you have waived, you understand I can do that at no extra expense to you and you're agreeable to waive that and proceed with your guilty plea today. Is that true?
Correct.
Your Honor, I'm going to tell that.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge, dismiss the original charge for the plea agreement. I'm sorry, there's nothing to dismiss. I'm sorry. Do you want immediate sentencing, counsel?
Yes, Your Honor.
All right.
I don't know if Your Honor is familiar with Ms. Cook. She has documented mental health issues. Her record reflects that she just pled guilty on a drug case out of Wayne County.
That originated here also. That originated in Wyandotte also.
There you go, Your And so she's been placed on 2 years probation. I know there's some delay in getting that started. Her probation officer had retired. She's got an appointment. She does tell me she is attending and was attending that as AA and NA. And, I mean, this is a circumstance she finds herself in. She's got 14 days for a misdemeanor charge. And she is held there because she was unable to make the bond. So we'd ask the court to consider, sentencing her to time served. The fact is, she is going to be on probation on a similar charge out in Wayne County. And that's going to be for a 2-year period. So this court placing her on additional probation conditions, to me, that seems to make sense.
Okay, well, the court will, there's a matter out of the 33rd District Court that there was a warrant for because your client wasn't at court. And it looks as though the warrant was issued the same day she was arrested, March 24th of 26. The court will also note that, and then that was for larceny. Then there was another matter that your client failed to appear on in the 23rd District Court. So that, in addition to the fact that your client was on probation, felony probation for attempt felony, controlled substance possession of methamphetamine in the 3rd Circuit Court, and then 2 other felony matters were dismissed. And then a mere 3 months later, she's back in this court for another drug charge. Those are all the reasons that this court took into account in assessing the bond. The court will also note that given the drug issues that are currently plaguing this city and this region, the court has serious concerns in this matter. And I don't know that 14 days jail is necessarily appropriate. Because what she was on probation for possession of meth, is the same thing that she was had in her possession in this case.
It was
So,
found in my bathroom.
I'm sorry?
I found it in my bathroom garbage. That's why I was handing it to the police at the door. That was not mine. But I'm gonna take claim to it because I want to get this case over with.
That does reflect what's in the police report.
I understand.
Very strange.
Well, I believe that the police were there on a well-being call initially, correct?
I don't know that.
I'm sorry?
And I don't know.
Yeah, I don't recall.
It would strike it, I'm
I believe that there was, because there was,
the police report itself, first thing the officer states is that she has no mental health issues.
right. Ma'am, and you're not in the 3rd Circuit Court Mental Health Treatment Court as a result of your felony conviction?
No, I'm not.
All right, based upon the circumstances in this case, the court's going to order 30 days jail, credit for 14 days. And the court will waive the fines and costs. All right, good luck to you, ma'am.
Thanks.
Thank you.
Have a good day. Okay. All right, well, we're gonna go on the record in the matter of the city of Wyandotte versus Michelle Yenna, 26443 and 25418.
Will we be addressing 221318 as well, you want?
Well, I don't, let me see. All right. Yeah, yes, also this one as well. 21318, yes. But these are all Okay, I don't know what one, these, so I wait.
Those are bus plan.
Yeah, I understand that. Not the 26 case, that's not a probation violation.
Correct.
So let me put these with the files. Two, 138. Okay. All right, so these are for the probation violation over here, the 22 case. Okay. Then we have so the state of Michigan is the 25418 matter. Felony matter, that doesn't get this one. Yes. Okay, counsel, your appearance, please.
Your Honor, good afternoon, Richard T. Serrano, P33828. Your Honor, I appear today on behalf of my client, Michelle Yenna, who's in Wyandottes custody presently, and I'm appearing on all matters for arraignment only. Ma'am, please state your name for the record.
Michelle and Yana.
All right, ma'am. Well, it's been a while since we've seen you. So we just saw your husband or ex-husband not too long ago. He seems to be getting his stuff on track. Hopefully you are too at some point. So we have the state of Michigan with a felony arraignment because your client failed to appear for that back on May of 25. Then she claimed she was coming back in July, on July 3rd, and she never came back for that either. So we have the arraignment on that one as well, counsel.
Right.
So let's go with the arraignment on the 26 case, the new case. As to that arraignment, counsel.
As to arraignment, Your Honor, I've spoken to my client regarding the nature of the charges. She understands. She's been advised of all of her constitutional rights. It's signed a form regarding that. Hereby today we waive formal reading, stand mute. Absolutely not guilty to be entered.
Okay, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then we will schedule the pretrial for April 22nd. What does that day look at, Alicia, for a time?
That gets getting pretty full.
I mean, it sure is.
10 a.m.
Okay, 10 a.m.
Yes.
All right, thank you. And then counsel, as to the felony matter, to the arraignment.
Your Honor, due to the serious nature of the case, my client wishes a formal reading of that charge, please.
Okay. All right, we have a complaint that alleges on June 7th of 2024 that you did while in the city of Wyandotte, being the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Kyle Guth, a police officer who was in full uniform, and the officer's vehicle was identified as an official police vehicle acting the lawful performance of his or her duty, directing the defendant to bring his or her motor vehicle to a stop, did willfully fail to obey that direction by attempting to flee or elude the officer in an area where the speed limit was 35 miles per hour or less. This is a felony charge. The maximum penalty upon conviction is not more than 5 years in state prison and or a $1,000 fine. Secretary of State shall suspend your license for 1 year. Counsel, are you satisfied with the reading?
Yes, Your Honor, thank you. Your Honor, we enter the mute in that for arraignment purposes.
Ma'am, you have the right to have an attorney. If you're unable to afford an attorney, you may request, or you may have one appointed to represent you. You did in fact have an opportunity to speak to an attorney today, correct?
Yes.
Okay, I need the
Yes.
felony court appointed form. I need the felony appointed form, please. That may have already previously been completed, but she failed to appear. No, she never was here. All right, you did have an opportunity to speak to an attorney today. Yeah. The court's also signing the petition in order for appointing an attorney for felony matters as well. And you, ma'am, have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on April 16th. At
11:15.
at 11:15 a.m. And counsel asked to bond in these matters.
Your Honor, do you want her arraigned on the violation of probation as well?
I'm just waiving an arraignment, entering a plea of not guilty. It'll carry on with the rest of these.
Thank you. I was gonna have to combine everything except of course the felony, but please put the 2 misdemeanor matters on my record court date, please.
I'm putting the probation violation on with, on the 22nd with the misdemeanor.
As to bond, Your Honor, may I address it?
Yes, please.
My client got arrested last night. And she tells me that she worked 30 years at Ford, was subsequently fired, and she's waiting to have a retirement income coming in, but right now she has no income coming in. She is not on probation or parole, nothing pending other than these matters, of course. Your Honor, in speaking to my client, one thing she stressed is that although she deems herself homeless, she goes every day to see her elderly mother who has a nurse come in and drain her lungs for serious medical conditions. So she is helping her mother predominantly. But again, I told her these are serious matters. You're gonna have to arrange to have someone else perhaps provide for your mother, which leads us to the next concern of my client. She pretty much came out and told me, I want to get off drugs. So that's a good step in the right direction. So that's what we're here for, and that's probably the source of all your problems. She agreed. She's not under any influence of any drugs or alcohol at this point. She understands fully what we were talking about, I believe. But Your Honor, I asked the court to consider. I won't even ask for a personal bond because I don't think that's gonna be granted. But Your Honor, in addition to any bond that you may assess, if the court decides to assess a high bond that she cannot post, we ask the court to consider marking her file medical. She does have required from spinal meningitis. Again, the ongoing drug problems that she says she has. We'd ask the court to perhaps consider tethering her to a treatment facility through the Wayne County Jail. She said, I'd love that. Those are her words. But we leave it in the court's discretion as to bond.
All right, well, ma'am, how is it that you are supporting yourself if you are not working?
Sienna, did you go to court?
It's been hard. It's been really hard. I mean, I've been struggling.
Well, correct, but you've also been avoiding the court here, ma'am. So, tell me, ma'am, if you test right now, what's in your system?
Everything. I mean, heroin.
Talking about non-prescribed medications, ma'am. Nothing that you have a prescription for. What else?
Heroin and crack. Pot.
Okay. Well, here's, I mean, your client does not have a good track history in this court, counsel. And then not only does she have 2 warrants for her failure to appear, but then she's in custody on new charges. One of which is possession of controlled substance, which is, seems to be potentially the source of a lot of her problems. So the court's going to note, based upon the allegations in the 25418 and the circumstances surrounding Miss Yana and her continued failure to appear, the court's going to order on the, as I just indicated, the 25418, the court's going to order a $10,000, 10% bond. On the 26443, the court's going to order a $10,000, 10% bond. And on the probation violation, the 221318, the court's recalled the warrant. And the court's going to issue a $5,000, 10% bond on that matter. And the event bond is posted, you're not to possess or consume any alcohol or drugs that are not prescribed, and you're not to be released without a GPS tether through the Wayne County Jail, house arrest. I will mark the file medical at your request, counsel.
Thank you. Will she be tethered to a treatment facility or?
She can request it, but we can address it also next Thursday.
All right, thank you.
Okay. Good luck to you, ma'am.
Thank you.
Thank you.
Thank you.
All right. All right, let's go on the record in the matter of the city of Wyandotte versus Danny Richards, 26391. Am I going too fast, Alicia?
No.
Okay.
Good afternoon, Your Honor. Neil Boyd here on behalf of Jim Richards, who joins us from the Wayne County Jail. Mr. Richards, can you hear us? Would you please state your name, sir?
Yes, Danny William Richards.
Thank you.
Thank you.
You're welcome.
And so today is scheduled for the adjourned pretrial in this matter.
Yes, Your Honor. Had an opportunity to review this with Mr. Richards and as well as with the city attorney. And Mr. Richards was prepared to offer a guilty plea to count, what count number it is, the paraphernalia charge.
Count number 2.
Count number 2, count number 1 will be dismissed.
All right, sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, sir, and I do.
All right. And sir, you heard the plea that was placed on the record, correct?
Yes, Your Honor.
And as to the possession of drug paraphernalia charge, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights?
Yes, Your Honor.
And you also understand, sir, that by entering into this plea, you'll be waiving some of those rights.
Yes, I do, yeah.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Okay. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
All right, counsel, if you can please order your client.
Yes, sir. Well, Mr. Richards, you recall being in the city of Wyandotte on about the 27th of March of this year?
Yes, sir.
And you were over at 1314 Walnut Street, which I think is relatives' home, is that correct?
Yes, sir, that's my mailing address.
At that time, you had an interaction with some Wyandotte police officers, is that correct?
Yes, sir.
And
I mean,
during
yes,
that-
sir. Yes, sir.
During that interaction, you, in fact, had in your possession, in your pocket, you had a crack pipe. Is that correct?
It was in a cigarette pack, yes.
In your pocket, is that correct?
Yes, sir.
You're unsatisfied with it?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge of possession of drug paraphernalia and dismiss the possession of dangerous weapon per the plea agreement. And counsel, you asking for immediate sentencing?
Yes, Your Honor. Looking for a sense of time service. Mr. Richards, the court's probably familiar with some of his past. He suffers from some severe disabilities, which I think leads to some of this other behavior. He's got a disability, I think, and has some mental conditions, you know, autism, PTSD, etc. Taking all that into consideration, and he's been apparently in custody on these particular offenses, which I think is 14 days. Yes, the court to consider that to be sufficient punishment in this regard.
All right, well, Mr. Richards, you have a matter pending in out of e-course from February, correct?
Yes, yeah.
Right, what's happening with that?
I'm supposed to go back on the 22nd. I believe I was on tether when this happened. I was tethering at my dad and stepmom's house.
Yep, yes, you have two matters out of the Lincoln Park court, one from Lincoln Park on February 2nd and one from e-course from February 13th.
The one from Lincoln Park was supposed to have been dropped down to a civil infraction, I believe. I was supposed to pay it I might have been in jail when I was supposed to pay it. I have money in my social security account, but I couldn't get them to release it to my dad, so I have to do it in person.
All right, well, sir, aren't you getting kind of tired of this rigmarole?
Excuse, can you repeat something?
Aren't you getting kind of tired of this?
Yes, I've been in jail since '96, so this is all really stressful on me. I don't plan on, I said it's been really stressful. I haven't been to jail since '96, so I've had a clean record and had my license back. I have had doctor's appointments lined up. I'm very tired of it. Yes, sir.
Sir, are you looking for treatment or what's going on?
I just need the psychiatrist and doctor. I had it all lined up, and someone kept stealing my stuff. So I had a couple reports on her. No one ever did anything. So I'm just planning on moving out of the neighborhood. I have disability.
Sir, that wasn't my question. My question was, are you interested in treatment?
No, I don't
Drug
need
treatment, alcohol treatment. Are you interested in addiction treatment?
I don't need it.
No. Okay. All right. So here's what the court's going to do based upon the pending matter, based upon the charge in this matter. The court's going to order 30 days jail, credit for 14 days, going to waive fines and costs. Have a good day.
Yeah, thank you.
All right. You ready, Ellie? Let's go on the record in the matter of the state of Michigan versus William Carney 2644. And Sergeant, your name for the record, please.
Sergeant Stephen Oborn, O-B-O-R-N-E.
Thank you. Please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, nothing but the truth.
I do.
Sorry to pile on, but this is not the, I need a felony incorporated form. That's right. All right. And so Sergeant, you may proceed on the warrant, please. I can just fill it out. That's fine.
Okay. On April 7th, 2026 at approximately 22:47 hours, Officer O'Meara and Officer John Cox were operating a double man unit, which was a semi-marked patrol vehicle, when they observed a silver Mercury Sable with license plate EZH 7783 traveling southbound on 4th Street near Balmy, with objects hanging from the rearview mirror obstructing the driver's view. Officers checked the plate through lean, and it indicated the EIV in the vehicle was N. Officers also observed the driver to be a skinny black male. Officers activated their overhead emergency lights and initiated a traffic stop on the above vehicle on southbound Ford Street near Oak. The driver of the vehicle observed the lights and eventually pulled over about 3 blocks from the initial stop on Phelps, just inside of Southgate. As officers approached the vehicle in their full uniform, the driver decided to flee, squealing the tires and accelerating at a high rate of speed. Officers returned to their patrol vehicle, activated their audible sirens, and began to pursue the fleeing vehicle. While pursuing westbound on Phelps, speeds reached 50 miles an hour in a 25-mile-an-hour residential zone. The driver of the fleeing vehicle disregarded all traffic control devices and signs. The pursuit eventually ended up on eastbound Eureka Road and into Wyandotte. Again, the driver disregarded the red light at Fort Street, which is a major intersection, jeopardizing civilians, officers, and his own life. The pursuit continued eastbound Eureka, reaching speeds over 90 miles an hour, which is a 40-mile-an-hour zone. The driver decided to turn southbound onto 11th Street, lost control, struck a gray Nissan in the parking lot of 331311. After striking the vehicle, the driver decided to drive down the sidewalk on the east side of 11th and ended up colliding into 2 different utility poles near Orange and coming to a stop. The driver decided to exit the vehicle and flee on foot and started to jump through the backyards on Orange. Officers lost sight of the driver, but later received information from someone who saw a black male get onto a bicycle and head westbound through the alley near Eureka Road and 12th. Officer Parsons of the Southgate Police Department, who was assisting, located a bike on the ground in front of a garage door of 1303 Eureka Road and could hear 2 males speaking inside. Wyandotte officers made their way to that location and eventually ordered the 2 males out of the garage. Officers immediately recognized one of the males to be the driver, who was later identified as William Kearney. The other male was John Turner, who was later released. As officers were taking Kearney into custody, they observed him to be out of breath, his clothes and face were dirty. And at the same time, Kearney stated, "Done," and that y'all got me. And he also explained that he ran because he had warrants. While searching Kearney, Officer O'Meara located a bindle and a small cellophane bag inside the right coin pocket of his jeans. The bindle and cellophane bag contained a white powdery substance, which later was identified as cocaine. Officer Mira also located a large cellophane bag inside Kearney's right jean pocket, which also contained a large amount of white powdery substance, which was also later identified as cocaine. While conducting the inventory search of Kearney's car, officers located a multitude of cellophane bags and a blue digital scale, which had white powdery substance on it, which was later identified as cocaine. Kearney was checked through lien. It revealed that he was not licensed and had a valid warrant out of Ann Arbor for a probation violation on a CCW and R&O charge, and 2 FTA warrants out of Dearborn for MIP and public order crimes. All the suspected cocaine tested positive with a searching narc cocaine swipe, and the total weight was 12 grams.
Upon examination, complaining witness, I find the offense charged or committed that there's probable cause to believe defendant committed the offenses. And counsel, where's Mr. Serrano?
I'm here.
He's right here.
Oh, all right, counsel, your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P33828, appearing on behalf and with my client, appears to my right. Show yourself for the camera. All right.
Your name for the record.
Your Honor.
Your name for the record, sir.
What's your name?
William Kearney.
Okay. And so counsel, as to the arraignment.
As to arraignment, Your Honor, I've met with my client, advised him of all of the charges against him, all of the maximum penalties involved, and be it from this court or any administrative agency, I believe he understands them all. He's been advised of all of his constitutional rights. He has signed a form regarding that. I've given to the court officer. And Your Honor, we stand mute as for pleaded not guilty to be entered on all matters.
All right, the court will waive the formal reading. And sir, you have the right to have an attorney. If you're unable to afford an attorney, you may have one appointed to represent you. And you have in fact spoken to an attorney today, is that correct?
Yes.
You also, sir, the court signed the petition order for court appointed or for appointed attorney in this matter. You also, sir, have the right to be presumed innocent until proven guilty of reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, ma'am.
I'm sorry?
Yes.
Speak well.
Do you understand
Clearly.
those rights, sir?
Yes, ma'am.
The court's entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference for April 16th,
8:45.
8:45 a.m. And counsel as to bond.
Your Honor, as stated by Sergeant Oborn, my client is aware he has a bench warrant for absconding out of Washington County. If and when he's released, he will address those matters with his and with either his attorney or himself. He intends to ask for appointed counsel. He does say that he doesn't recall the Dearborn warrants, but is also going to check into those if and when he's released. My client tells me he's single, he supports 3 minor children, and Your Honor, he works on the weekends as a lounge security for a bar called Live in Ann Arbor. He also works as a fabricator for steel dip hydraulics, steel dipping hydraulics. He's employed there as well. So, Your Honor, he is gainfully employed, albeit has not timely failed to appear, but I'm trying to get his bond as low as possible, Your Honor. He doesn't have a lot of money to post, but I've asked him to, he's going to make some phone calls to try to post his court's bond. We leave it in the court's discretion.
All right, so sir, you work on the weekends?
I work every day. Really.
Okay, where is it you work, sir?
During the week, I work at the car shop, and then on the weekends, I'm a bouncer at like the just
Okay.
Fridays.
All right, so the matter that you have a warrant out of Ann Arbor, is it because you're on probation in that case?
Yes.
Okay, and what year is that from?
2015.
Yes. So that tells me, sir, that you have failed to appear a number of times because your probation is 2 years and you were sentenced in 2016. We're 10 years later. You should have already been discharged from probation.
Yes.
And you
That's
have,
not
and you,
a failure to appear.
what's that?
That's not a failure to appear. It was well, I guess it's not a failure to appear. Never mind.
Okay, when did you fail to appear, sir?
2017.
So for 9 years, you haven't gone to take care of your warrant.
Trying to get my life back together, and I was gonna go take care of it.
In 9
Your Honor,
years, sir, you haven't been able to do that?
No.
I was going to
this
say, Your
doesn't-
Honor, the only good thing we could surmise from that is that in the event that he was approaching to be public enemy number 1, we would have heard about him here than today. Any criminal charges in the past 9 years, that we'll leave it at that.
Well, I don't know that that's necessarily a successful argument, but in any event, sir, are you out on bond in any other jurisdiction?
No, ma'am.
Okay, tell me about Dearborn. Why do you have a warrant out of Dearborn?
I honestly have no clue. I don't even recall ever being as much as with somebody that was pulled over by Dearborn.
Well, let's see. It's from 2011. Perhaps that may be why you can't remember. And it was a minor in possession. You failed to appear in court for that, as well as a urinating or defecating in public. Does any of that ring a bell for you, sir?
No, ma'am.
All right, well, that's what that's for.
Couldn't even
So-
walk into that.
What's that, sir?
Couldn't walk in 2011.
You couldn't walk in 2011?
No, I had been shot
Okay,
twice.
well, what month were you shot, sir?
February.
Okay, well, the date of the
I
warrant
have
was
all-
October, so I'm not sure. But in any event, sir,
From Tennessee.
this seems to be you. Same date of birth, same name. Were you, when did you live in Ypsilanti?
When we talking? Around that time?
I'm asking you, sir, when did you live in Ypsilanti?
I lived in Ypsilanti quite a few times, man.
When
What's
was the
that?
last time you resided in Ypsilanti, sir? What year?
I want to say 2022.
Okay, well, that's the address they have for you on the warrant, so. When did you move to, your address in Detroit, sir?
2022.
And how many children do you have?
3,
How old are they?
9, 4, and one is about to be 2 in 10 days.
All right, and who do they live with?
Their mom.
Their moms, multiple moms?
No, man.
They have one, there's one mom for all 3 children?
Yes.
Okay, well, Sergeant, would you like to address bond?
Yeah, Your Honor, due to the,
Go ahead, sir.
due to the events that's happened, fleeing elude, hit and run accident, R&O, running from the police and all that, and the warrants that he have, the severity that he put the people in jeopardy, his life, police and other civilians, I'm looking for $75,000.
All right, the court would agree that a minimum $75,000, 10% bond would be appropriate, given the nature of these charges, the failure to appear history of Mr. Carney, and the danger that the community has been placed on as a result of these allegations. So the court, while it finds $75,000 would be a minimum, the court's going to order a $150,000, 10% bond with the following bond conditions. You are not to operate a motor vehicle, sir, at all. You are not to be released without a GPS tether through the Wayne County Jail. And you're not to possess or consume any alcohol or drugs unless prescribed. And we'll see you back for your probable cause conference on April 16th. Thank you. Have a good day.
Well, kids, it's been a long night. Oh, all of my technical issues are just going to compound on top of each other to make it where I can't even end live stream. Oh my god. Sorry, I've been technically troubleshooting and breaking things all over the place. Right here. Did that fix it? Yes. Oh dear. Well, some days are better than others with the whole streaming game, especially when you're live without a net. Sorry about the whole bottom third chat thing. I don't know what's going on with that. It seems like it kind of wants to work, then it broke a joke. I don't know. It's not all about the chat on the bottom of the screen, though. It's all about the court cases. And man, we had some good ones today. A lot of stuff to learn from other people's mistakes. I don't know about you guys, but it helps me keep grounded every once in a while. Helps you remember when you're an adult. Sometimes you just got an adult, no matter how much you want a kid. That's just all there is to it. But man, Middleton. He's leaving that courthouse. Tomorrow's the last day. I'm going to get whatever I can get, whatever he's doing. We're going to watch some of that. Final day, legendary courthouse. Final day with Blackboard. I don't even know what we got coming in towards the end of it. But I know what I got another day of court ahead. We have another one of these little court get-togethers watching the best court cases of the day right here. Same Wolf time, same Wolf channel tomorrow and every day after that, all the way through Saturday. We'll be here brunch Saturday, watching the best of the week. Because that's just what we do. And chat does chat. Thank you, Crafty. Thank you, Felix. Thank you, Mama. Thank you, Steve. Thank you, Julie. And Shiloh. Everybody's name I can see on the screen. I really need to be able to scroll down. I know some people gave some benefits. As a matter of fact, it was Wixel. Of course, he was paying his late fee of all things. I tried to say thank you. You know, when I get troubleshooting, I get in that little zone. It all just kind of goes wrong. Ladies and gentlemen, while things are going wrong for me, they're going wrong for people on the screen too. Going right for all the rest of us though. Trying to watch support. When things go right, they go right. When they go wrong, they go wrong. I think there's a thing. Y'all have a great night. I'm your lone wolf Hoosler. I am out. Man, I after today, after tonight, I just don't even know. I'm just gonna vent for a minute here. I don't have a redirect set up, which Hutch may be streaming. I'm not sure. Go out there and check things out. Yeah, all our friends, and you know, this is our call out to Ferris Bueller's Day Off. There's nothing else to watch here, but I try and get these little nuggets of wisdom in here, and our little nugget of wisdom today is remember, an apple a day will keep the doctor away, especially if you throw it hard.